going to start with what's been going on since the from the last hearing. We're going to go over the last hearing that they had, which was on the 26th of November, 2024. And this is the Commonwealth of Massachusetts versus Karen Reed. This is the retrial, and we're in pretrial conference and motion hearings, and we have some specialized hearings coming up. We have a Dauber hearing coming up, and in this image here, you're going to see the new prosecutor. This is Hank Brennan, special prosecutor brought in. And we have Karen Reed, and of course, her previous attorney from the first trial, David Yannetti. She still has Alan Jackson. She still has Miss Little. And they have brought on a new attorney, Mr. Alicio, that they did get approval for from the judge right away. We have the same judge for the retrial. We have Judge Beverly Canone. She was special ordered to cover it from the special magistrate above, like actually put the chief justice above, actually put in an order saying that she was assigned to this case and to stay with it. Um, it wasn't actually put in through rotation. Okay. Karen was not very pleased with a lot of things that have been going on in the hearings. One thing I would like to mention in regards to this retrial, if we go to trial, Karen Reed is really going to need to work on her expressions in front of the jury, because she's got one of those faces that can kind of like just tell you she's annoyed like right away. And it would be good to put your best foot forward, but the cameras are catching a lot of faces of Karen Reed, and they're not good. They make her look entitled, judgmental, annoyed, angry, um, disrespectful, even when the judge is speaking. I mean, there's been lots of comments about it. I don't think I'm the only one, but I'm hoping they can work on that a little bit. Okay. But meet Hank Brennan. Hank Brennan, he is the new special prosecutor. He's got 25 years of experience. He's a seasoned attorney. He's most commonly known for his defense of Whitey Bulger right there in Massachusetts. He was a defense attorney for a very long time. Okay. He's got an extensive background. But, they had Lolly. Well, Morrissey had Lolly, prosecutor Lolly, with the case. And a lot of people said, like, he talks slow and he put forward a kind of disjointed prosecution case. I mean, he has a totally different style. Um, Hank Brennan, from what I saw in the hearing, and we actually have that recording for you in the playlist for Karen Reed, and you can check that out. It's the whole recording all the way through. You can watch him in action, and I recommend that you do, because he's the kind of prosecutor that some of us following some of the other trials really like to see. He comes at it from different angles. He's crossing the T's, he's dotting the I's. He's kind of picking up some loose threads from the previous case. Um, and I'll get to why I'm saying that in a moment, but just a little bit more about him. When he was appointed, his first statement was that he is 100% committed to ensuring a fair trial for Karen Reed. That's his first primary, and to meticulously present the facts surrounding John O'Keefe's death in the courtroom. In other words, to make a clear picture of everything that happened that night and why Karen Reed is being tried. And but keeping fair and the legal law and order as the paramount. Now, there's a lot with this case. Anybody that's following it knows if you even mention it, one side or the other out there on Twitter or out on any of the socials or anywhere is going to get at you. Okay. And I understand everybody feels strongly about it. There are people that feel that Karen Reed is being set up. There was a whole third party thing that was put forward during the first trial, which some of that is still bleeding in. There is definitely a whole movement that she's being persecuted. There's been lots of mistakes made in the Commonwealth. There have been some bad apples in law enforcement in actually the Commonwealth there, in that they have been feathered out and things have been done, things have been said, charges, people losing jobs. It's a mess, okay? But it doesn't mean things didn't happen. And it doesn't mean that all the evidence is bad. And that's Hank Brennan's new job, is to present a case with solid evidence and trying to get through the drama and everything from the first trial and present a clean case. I don't envy him. He doesn't have a lot of time to do it. We are on schedule for January for this trial. That could change. It could. I do believe both the state and the prosecution would like it. This is an image of Frank Brennan in the last hearing on November 26th. Of course, he had Prosecutor Lally and Assistant Prosecutor Miss, I believe it's McCarthy, from the last trial with it. They're very valuable to be part of the team because they actually have all the evidence. They have the history of what happened in the first trial. They are invaluable in helping him present a good case. But he did all the talking. He's the one at the podium doing his oral arguments to Judge Canone, rather. Sorry, Judge Canone. Uh, he was the one presenting the case for the state, the oral arguments for all of the motions. Okay. The Reed family was there, and I captured this picture because they didn't look too happy. One of the motions in the November 26th hearing, it was all about the Rule 17 motions, and they were to get additional evidence, subpoenas for additional evidence that was not in the case file from the first trial. And we have two issues here. Judge Canone repeatedly reminds the defense and the prosecution this is a new case, and some things were left open, that we can actually go after new things and present new motions and go that like everybody gets a fair shot. And she means everybody, both sides. Okay. She's not going one way or the other. I know she takes a lot of flack by favoring one side over the other, but I heard her repeatedly deny prosecution motions and actually support defense's reasoning for not allowing that to go. And she does it not based on preference. She's actually listing case law. Okay. Like she's actually looking at the law to do it and saying whether they meet the criteria or not. I've just seen a lot of flack about that. Just saying that, she's not a very popular judge. I'll say that. I have no problem with her. I'm not, as her style can be very off-putting. She can. But I do see her getting the information out of both sides, and she just does it in a way that people just aren't expecting. I mean, she does it in question and answer, and her pushback sometimes is very direct and very on point, and it's done in just a conversational style. And I can actually see where she's coming from and the legal point that she's making, and she backs it up later. But in regards to the Reeds, there was a Rule 17 motion put forward by Hank Brennan right away. He did get, as we talked in last time, he put in that he wanted to retest the technology, the telemetrics for Karen Reed's vehicle. And because of some failures that happened, that all got approved. That was agreed by the defense and the prosecution. The judge okayed it. They came up with a time frame. They came up with the experts when it would be done. I do believe that's going to be done in the beginning, right now, in the beginning, turned over with the defense. The defense will have their expert witness too, witnessing it all, and then they'll all look at it and put everything forward and file their motions back and forth in regards to it, supposedly in time for the January hearing. But that could be a bone there too, because they have to rely on expert witnesses that have to prepare reports, and they could actually throw a monkey wrench in it by lagging behind. It's been brought up. I wouldn't be surprised if we see a motion forward on that they need more time, but we'll see. Right now they've got the schedule there, and it looks like it could be done by January, but we have to kind of wait until they tie a bow on it. The other motion that came forward, one of three, was for William and Janet Reed's cell phone information for the month prior to the calls that they end the day of the calls of the incident, that they are saying Karen Reed tried to contact her parents. And they did do good oral arguments. Okay. They did actually, I do believe that the arguments in regards to on Hank Brennan's side were to show that Karen Reed did not ordinarily contact her parents in the middle of the night at 1:30. He's saying she attempted to call them at 1:30 in the morning, that we can't go by her phone evidence because it had gone through a taint procedure to take out confidential things that should not be part of the case. And so there's not a full judgment, that the Verizon record has been put into question. So the defense is actually arguing, well, you have all of the records, you don't have to do it, you're not able to prove by the Lampard case, which gets mentioned over and over again in both motions, that you actually require it because there's a third source for it. He wants to show that it was unusual behavior on Kieran's behalf to call at 1:30 in the morning. Now, those calls may not have gone through. He wanted both parents' records, he explained to the judge, because he could try between the two of them to decide who answered the phone, Karen's mother or father. Um, because they're saying she tried to call both. And I do recall seeing like a call on a call log that was actually submitted by the defense saying that she contacted her father at 6 a.m. and right above it was like either a missed call or an unconnected call to the same number from Kieran Reed's phone. And it was around the same time that Hank Brennan was referring to. Now, they they just keep saying that the only call she got was at 6 o'clock. That is when they called. What his point was, she tried to call them. She tried to call them because perhaps she was upset that something happened. This was extraordinary behavior for her. This is not her normal routine. She does not do this. She doesn't call her parents. And he wanted the records for a month before to prove that. Well, that's kind of not how it went. While they were discussing it and talking about the phone, this was the look on Karen Reed's mom, Janet Reed, when Hank Brennan let drop that Mr. Reed would probably be a witness in the new trial, that he will be subpoenaed to come forward and talk about the conversation he had with her in the car, supposedly on her way to the hospital, in regards to the statements that she made. And he is calling him in because of statements he made in interviews that have been publicly circulated through the media of things that Karen said. And that's going to come up in a little bit. But mom looked a little concerned about that. And Mrs. O'Keefe looked a little bit upset about that too. Mrs. O'Keefe kept this face the whole time for the whole hearing. I'm going to go back to the Reeds as the picture for right now. The other motions that came up that were quite involved, very, very involved, in regards to the media documentation. That comes up with the Reeds too, because not only did William Reed do interviews and all, Karen Reed has done a plethora of them. Okay. And the one that involved Gretchen Ross is the one that is right now under Rule 17 motion, because previously they had sent in, the media organization and Gretchen Ross had sent in redacted copies of the interview tapes that the interview that aired were derived from, but they were redacted of all information in regards to what the attorneys had said. All three of her attorneys, Miss Little, Mr. Yannetti, and Mr. Jackson, were all in attendance with her, with Gretchen Voss, during these interviews. Okay. So there's no attorney-client privilege because Gretchen Voss was there. And that was a point that Hank Brennan made in requesting the unredacted recordings in full, all text messages in all emails between Karen Reed, Gretchen Voss, and the organization. He's entitled to any statement that Karen Reed makes, because if she chooses to not stay silent, she's already been read Miranda and she's been charged. Every word she says can be used by the prosecution any way they want. That's a fact. That's a fact that Hank Brennan made sure he said repeatedly during the hearing. If she chooses to go out there and tell a story, tell her side, I get to look at it, I get to see it all, and I get to use it in the trial how I see fit. And that's true. In actually, the attorney for, I'm trying to get his name. Attorney Robert Birch was the attorney for Gretchen Voss and the media company. They argued that Voss has been harassed. She had given an affidavit previously, because there was a previous hearing on this in the previous trial where Judge Canone said, we're going to give it redacted. I want to respect people's privacy and work product. This woman shouldn't be harassed, this and that. She kind of limited it, for the information that would get out. She was very strong on the harassment that was going on and people not getting like cell phones and emails. She didn't want Gretchen's privacy, violated by the text messages and this and that. And she had concern for the witness's safety, because this witness, Gretchen Voss, put forward some of the abuse and harassment that had happened. And she made a valid case. And so they had decided. But during that actual decision, Judge Canone had left it open for the prosecution to come forward if they wanted more, because they agreed with the defense after negotiating that they only needed this, this, and this, and they weren't concerned about the actual conversations of the attorney, and they could do without it, and they could redact it. So the media company and Gretchen Voss went forward, took the expense, and redacted all of the interviews. So they've got a number of hours of interviews, but they've got a lot of it missing. And Hank Brennan now wants it. And what he said, the reason he gets it is she chose to talk. She has changed her story several times, and then put forward that those redactions included no more than, 33 statements from Mr. Yannetti, 33 or 34 from Miss Little, and about 33 or 36 from Alan Jackson. And he's saying that every time they said something, she changed her answer to the interviewer. She altered her statement. Therefore, he wants to know what she originally said, why she changed it, and what she's saying now, because that is allowed. She chose to speak to the reporter. She has no client attorney privilege with the reporter there. They don't want this, of course. The defense is going to fight tooth and nail. This is one of the reasons you see Karen Reed frowning during the hearing, is they made no decision during the court. Although the argument was strong by attorney Robert Birch of the privilege and work product and her not being harassed and this and that, he did say, well, you already made a decision on this prior. Well, Judge Canone reminded him, but I left it open for prosecution, and this is a new prosecutor, and it's a new trial. And if he decides that he wants to pursue the rest, I'm going to let him file the motions to do it. And she heard the oral arguments from both sides in regards to it, but she has not made a decision on it. That's going to be big. She kind of gave the influence that she's really not into violating confidentiality issues with anybody else in regards to the case. The defense actually brought that forward, that she had not let them subpoena third parties involved in the Alberts home that were at the party, and access to other people's cell phones. She has been pretty strong on privacy for certain things, um, and that may have led to some of the argument in regards to the Lambert issue, in regards to the cell phones, because she did deny them. She did deny Hank Brennan having access to that. Let me get to that one for you. So on the 29th, a couple of days after the hearing, which was on the 26th, she did deny that prosecution's motion to acquire the phone records of William and Janet Reed. This was one of the motion 17, uh, Rule 17 rather, that was put forward on the 26th. And she actually stated in argument that Miss Little had gone through the four parts of this case, which is Lampron and Mass, on the four ways to prove how you can get additional information after the end of something, after discovery, to get additional information, but you have to show the need. In She actually gave him credit. She said, despite the detailed arguments articulated in the supporting memorandum and at oral argument, the affidavit in support of the motion is insufficient on its face and fails to meet the requirements of Lampron in Mass. R. Crim, page 13A2. And this was an argument that Miss Little put through um, during the hearing. This was handwritten, so I just like put it up there for you, but she like hand wrote there. So she denied it. So Hank Brennan doesn't have access to William Reed's records, but he will have access to William Reed. So he's just not going to have the backup to impeach him. But it's going to depend on other things, because remember, we still have to hear if the media is going to be held to subpoena in regards to the William Reed interviews and the Karen Reed interviews. And there were multiple organizations that were listed. Okay. Now, the prosecution can potentially refile the motion to obtain Karen's phone records. They can reevaluate and correct it. They can put more substance in there that actually meets Lampron if they have it. Okay. They have to actually, meet the legal standards. Okay. Because it is third party records. William Reed is not charged in this case. He's not been impeached. He wasn't on the witness list. There's no prior testimony to go back to. It's third party. They can provide it as new evidence if there's new legal argument to justify the need for it more than what he's already presented in regards to the times, saying that it was unusual behavior. I guess here's the scenario. And this is pure speculation, but this is how it could go. When it goes to new evidence or argument, say she allows them to get the records of the interviews from any of the media. And in that media, either William Reed or Karen Reed says, I missed a call. Like I tried to get a hold of them and they weren't answering. Or he says, and I looked at my phone and I saw she had called before, but I didn't hear it. Anything like that could actually start this whole thing over again. Do you see what I mean? It's also up to the court on whether they allow him to actually allow the prosecution to actually go to any avenue to refile it. A revised motion could be corrected with additional information and may be considered, but that's going to be up to her, to Judge Canon, to decide. There's been acknowledgement that the prosecution might file more motions for similar records from other parties involved, suggesting that like this is part of an ongoing legal strategy to document better all that they believed happened this scenario, to make a more clear timeline with evidence and proof of the scenario of how the incident happened that they're accusing Karen Reed of. Okay. It's going to need a lot of convincing because there's already been a trial, and trials coming up pretty quickly now, and we're pretty much through discovery. So right now, we still have decision pending on the Rule 17 materials for the media interviews. Okay. She has decided on the phone records for now. That's until there's an appeal of it or an actually new I don't think you can appeal it, but there's nothing to appeal if it doesn't meet the standard. But you can actually address it in the court with new evidence on it in a new motion regard if there's something that was missing or more substantial information that could be added. There is no decision on the filings from the defense and the prosecution, both asking to delay the trial till April of 2025. All right. That came up in the hearing. Again, no decision was made. She has taken it under advisement. She heard their reasonings. Basically, they want to be able to go over all of the new evidence that might come forward through December, get through everything that has been added to the case. They also want to be able to do a precise witness analysis so that there could be less witnesses, more concise presentation of the case. And this came from the prosecution side, from Hank Brennan himself. He wants it clear and doesn't need like 5 people to say the same thing. And actually that kind of perked up Judge Cannon's ears a little bit. That was really good news to her because we heard the same thing over and over again in the first trial. Would you agree? Like, yes, we did hear the same witnesses saying the same thing. You don't need 5 people to say the same thing. So we're going to wait and see what happens. Maybe we'll find out in December about that, because by the time the December hearing happens, we should hear during that hearing from the prosecution whether their expert for the telemetrics has been able to provide the report and give it to the defense. And there'll be some back and forth about that in timing. So, we'll see. That may contribute. She may be waiting to find out about that to make her decision for April. It makes sense to me, until she knows what's going on with the telemetrics. Why would she make the decision? Unless it's a pretty given that it's not going to be available. All right. And also there was discussion during the hearing. The defense is working on the sidebar transcripts that were ordered that could be done, that they're going to keep amongst themselves for all the discussion to get everybody up to date. That will help Hank Brennan deal with some of the issues that happened during the trial, because all of this happened in sidebar. There's documentation, you get it from Lally and all, but if you have it actually there in the case, you can actually piece everything back together. They agreed to keep it amongst the attorneys and those that are working with the attorneys. Okay. Also, the state is working on Morrissey's test, because there is a motion from the defense based on the fact that there has been said that the prosecutor Morrissey had used a private phone to text mail to either email or text a judiciary in regards to this case outside the realms of what is normal or responsible. He shouldn't be doing that. So now they're looking at all of this in the state prosecutor's office. Hank Brennan has agreed to turn everything over, but during that hearing, something surprising came up. It had come to everybody's attention that Mr. Morrissey uses auto delete in 30 days, and that there's a time frame, like stuff's getting deleted, like we don't know who he contacted, and they wanted to expand it. They talked to Judge Cannon about expanding, getting emails and texts, not just to judiciaries, but to add both spelling of Reed's name, R-E-A-D, and R-E-E-D, to the search for these emails, because in the email that they have a problem with, he misspelled her name. And they want to expand it to include even judicial employees that work with the judges and people, so that there's a wider net to try to see what was happening. Okay. The other thing we have going on is the Dauber hearing on December 12th. Now, we'll have the Dauber hearing, but she could address some of these other things at the same time. The Dauber hearing is about whether or not the expert witness, the prosecution wants to make sure that the expert witness, Dr. Marie Russell from the first trial, that her testimony is admissible. Okay. This is the witness who testified that injuries that John O'Keefe received, that were documented in photographs from the autopsy, were from a dog attack. This is in regards to the defense claims in the first trial that Chloe, the Alberts, the residence where John O'Keefe's body, in front of 34 Fairfield Avenue, where John O'Keefe's body was found. Okay. The residence, it belongs to the Albert family, and Chloe lives with the Alberts. And this is in regards to the claim the defense is making that the Shepherd attacked John O'Keefe, and that proves that he was in the house. And also of note, the Alberts rehomed Chloe in May of 2022 after an incident with another dog. Apparently, there had been some documentation of her being aggressive with another dog in a bite, and they were having problems with her. And the plan was to rehome her like all along. And that happened. Just like there is the thing about them selling the house. They were in the process of decision to make the house well before the party they had in January. Well before that, and there's been documentation to show all of that. And yes, the house was, sold. They did want to sell the house, but everything came under a microscope because of these accusations. The defense is out there through other YouTubers and through other sources, putting out this third-party source that Karen Reed's not involved at all. She dropped him off. He went in the house. They did everything to him, dragged his body out here after the dog attack, and left him there. That was a scenario which was not brought into the first trial. They had no evidence of it. They couldn't, except for the dog bites, to cast doubt on the jury that the injuries that he received were from Karen Reed backing into him. Okay, there's been a lot on social media about this dog thing. I only have these here to show the third party intervention that is actually helping to spread these rumors. There was a missing dog poster put up by a YouTuber. There was in the Vanity Fair article, sorry, in the article itself for Vanity Fair, they actually, and I'm going to get you that because any of you that have Instagram, it's very interesting to read. They have a lot of points that were brought up in that Vanity Fair article that you may see some of the reasons why Hank Brennan wants those interviews. Let me just copy the link for you here. But they also talk about the dog because Karen Reed, she's still out there with this third party scenario that would actually cast doubt on everything the prosecution is actually saying. It's a completely different scenario. It doesn't involve Karen, except for Karen dropping him off. And it could be an interesting read for you if you haven't read the Vanity Fair article, which was done quite a while ago, and is going to be a part of this. Looks like it is going to be part of this retrial if these motions get approved. That's a big if. Okay. The prosecution's first motion for the Dauber, hearing, and this is it. This is what they're going to say. It's for reciprocal discovery because they are really going to hold this expert to the test. They want a thorough review of Dr. Marie Russell's analysis. This is what we're having the hearing for. So they have requested from everyone a detailed explanation of each wound as it relates to her conclusion of animal attack, a bite, a scratch, or something else. They want the exact species of the animal that she thinks did this. They want identify any wounds that Russell is unsure of. They want scientific basis for each opinion, all written reports that she has made on the case, and a list of all dog bite cases that she has encountered and actually testified for. And that's the part that might be an issue. Okay, they're doing a thorough drill down on that. But that was Hank Brennan's motion in regards to that. And that's what he is going to be looking at in the Dauber hearing. And then the defense, of course, will be presenting her as an expert witness, as they did in the first trial, or with her credentials, and only looking at the autopsy pictures. She did not see the bites. She only went by the photographs, from what I understood. I take that with a grain of salt. I'll take that back if it's proof otherwise. But I do believe she only had the photos. She never saw the bites. She didn't have anything else to go by. So another motion that's still out there is in appeal. And that is the motion to dismiss 2 of the charges against Karen Reed. And that is to prevent double jeopardy. And basically, because of the rumors of what some jurors had said publicly about coming to a decision on several of the charges, but not putting it that way on the verdict form, nor contacting the judge in regards to it on what to do or asking a question, they let it go. And nothing was done at the time when verdict for mistrial was put through, when they said that they were locked on that charge, on the first one. They said they were locked. They never actually said that they had come to a conclusion on the other two, although they're saying it after the fact. And that's the problem. You can't say it after the fact if you didn't say it during the process, okay? Because the defense then filed a motion based on what was being said to drop second-degree murder and the charge for leaving the scene of the fatal accident. They argued that retrying it would be double jeopardy. Now, double jeopardy is serious. You cannot be charged for the same crime twice if it's been jury adjudicated, if the jury has actually made a statement on it. That's the problem here. Was the statement made? Was it not? Now, Judge Canone said, nope, you didn't make your case here because the jury didn't do this. The jury did. You had opportunity to query at the time. You did not. Blah blah blah. She said, nope, legal standard. Nope, you have not admitted. She said in August, denied it, saying that the defense's claims lacked merit. They didn't come forward with a jury member. They're now appealing it to the Massachusetts Supreme Court. Okay, oral arguments were already heard in November from both sides, but the decision is still pending as far as I know. And she's actually going forward with the 3 charges right now. Now, if I find information in regards to that statement there that the decision is still pending, that they actually did come forward with an actual one, I'll update everything and I'll give you guys a message. But to date, I couldn't find anything in regards to it. Okay. That will be that is the end of the update for Karen Reed.